Hello and welcome everybody. This is Bernard Wolfsdorf. You are now live with our EB-5 webinar, part 3. This webinar will cover a variety of topics, but mainly the exciting topic of setting up a regional center and operating a regional center. We have with us, and my name again, Bernard Wolfsdorf. My so-called claim to fame is the fact that I am the past president of the American Immigration Lawyers. Lately I've been calling myself an EB-5 immigration lawyer. We file lots of 526s and 829s and 924s. With us, our honored guest today, Elliot Winer, the TEA expert. And for those of us who thought we know a little bit about TEAs, the truth is Elliot is the absolute expert in this particular arena. Mr. Winer, Dr. Winer was the chief economist and director of economic analysis for the Massachusetts Department of Workforce Development and is a well-known guru in the arena of TEA analysis. Some of us think a TEA is merely an area with over 150% unemployment or rural area with 20,000 or less. It's a lot more complicated than that, and Mr. Elliot Winer, Dr. Winer, will be explaining all of that today. By the way, I just got back from China, so please pardon my croaky voice. I did swallow a frog, and unfortunately, it sounds like it. We also have with us Mr. Jor Law, securities and corporate lawyer par excellence. He's the go-to guy that I reach out to in that particular arena, and Jor kindly joined us today. Jor will not be available for questions at the end. I will remind you to use your chat column. We will be taking live questions, and we will be answering all of your questions today, except Jor Law needs to sneak out of school a little bit early because he has a prior commitment. Also joining us for the first time, Dr. Aaron Goforth, president of Wright Johnson, LLC. We are delighted to have you here today, Aaron. Thank you so much for joining us. Wright Johnson, the business plan economic analysis specialists, truly very, very knowledgeable, and absolutely my go-to person when it comes to, as they call it, BPs and EAs, business plans and economic analysis. We also have with us today, again, thank you, our resident participant, Michael Gibson. Michael Gibson is the go-to person when it comes to due diligence and risk analysis, and he certainly opened my eyes in terms of what's involved in this program and how to undertake due diligence. Thank you, everybody, for joining us today. Real pleasure to have you online. We had over 300 people registered. We never get quite that many attending, but certainly a pleasure to see the numbers going up and up and up. Obviously, we are getting good feedback, and I encourage you all to share the news. Most of these EB-5 webinars can cost hundreds of dollars. This is a free webinar series, and please feel free to pass the information on to your colleagues and friends. This particular webinar will be available online. You can find it on YouTube after we have published it, and also on our website. So welcome again, everybody. Complete and pleasure to have you with us all today. Let's kick off. What is the EB-5 program? For those 1% of you who are not familiar with it, we'll fly through it. We have a lot of materials today. Bottom line is invest $500,000 or $1 million, depending on the geographical area. And if the investment creates at least 10 full-time jobs for U.S. workers, out comes the green card. Unfortunately, not so easy. The green card is a conditional green card, and it is removed that is, the conditions are removed and it is made into permanent green card if the investment is sustained and the jobs created. Boy, that looks so simple. Sustained investment, that means if the company fails and goes bankrupt, or if the appropriate number of jobs, although bankruptcy itself may not be the end of the road, if the company is in fact resurrected, that investment may be sustained, but the critical point is that the jobs be created. I cannot overemphasize the importance of job creation. This is more than anything a job creation program, and proving the job creation is absolutely critical. Now, what exactly is a regional center entity? Everybody knows the term regional center. Everybody's heard about it. What exactly is it? Well, here we are, folks. I don't like to normally read from PowerPoints because that's a little bit boring, but in this instance, I'm going to break the rule. This is not merely a defined geographic area, but rather a business entity that coordinates foreign investment within an approved geographic area in compliance with EB-5 statutory, regulatory, and precedent. Question is, nowadays, can you go outside the approved geographic area? And our economists will be answering that question. The answer is maybe yes, if you can show economic impact. Now, regional centers do not hold sole jurisdiction over geographic area. There's numerous geographic regional centers in the New York area and most other popular areas, including California and Los Angeles. Now, the purpose of a regional center, and this is kind of important, worthwhile going and looking at regional centers came into existence in 1993. The program is a 23-year-old program since 1990. Didn't really take off very quickly, so the regional center program was enacted in order to pick up the pace of interest. It certainly worked, and presently we have a very, very popular regional center program. The purpose of a regional center is to promote economic growth through increased export sales, improved regional productivity, increased domestic capital investment, and, I'm going to add, most important, job creation. So what is the responsibility of a regional center? Is the oversight of the 526, that's the initial immigrant visa petition filings, and the 829 removal of conditional filings. So that is a responsibility of the regional center. They will also obtain signed subscription agreements as the investors sign up to invest in the particular project, and of course will be responsible for escrow agreements. By the way, escrow is not required, but certainly that is a responsibility of the regional center to ensure that the money is taken in, held in escrow, released at the appropriate time, and all the conditions are required. It will also, the regional center will monitor direct employment as opposed to indirect employment, which obviously is primarily the work of the economists in determining actual number of indirect and induced jobs. One of the other responsibilities of the regional center, of course, is to track the infusion of capital into the job-creating enterprise. There has to be a nexus or connection between the capital investment and the jobs. And finally, the regional center will monitor compliance with the business plan, the original business plan, which is so important that folks like Dr. Aaron Goforth, who is one of our panelists, will prepare. And obviously, the business plan must support the foundational facts in the economic plan or economic report. So economic reports and business plans are the name of the game when it comes to centers and when it comes to job creation and explaining exactly how the EB-5 investment will qualify under this particular program. So what do you do in order to obtain regional center? you to apply to USCIS for designation approval. At the moment, all the 924s are being processed in Washington, the new primary facility for adjudicating EB-5 cases. They are processing all the 924s. People are talking about 6 to 8 months. We're seeing a rapid improvement for those poor folks who waited almost 2 years. We are seeing massive improvement in the adjudication coming out of Washington. The regional center also has ongoing responsibility for administration, compliance, and of course the selection of and marketing of projects for investors. The regional center, to some degree, will assist in ensuring due diligence regarding investors' source of funds. That is a very, very important component. Two fundamental components of your 526. One is showing that the has eligibility, and number two, showing that the investment funds were legitimately earned as well as appropriately transferred, showing the nexus between the original legitimate earning and the investment in the particular project. The attorneys can prepare the 526 packages and the 829 packages. For those of you who haven't filed these cases, average 526 or 829 package is running at about 8 to 10 inches. 829 packages, some of them that we filed, 16 to 18 inches of documents. My bad joke, you don't want to be dropping this on your toe. It could be a lethal weapon. Regional center entity has the responsibility for allocating jobs between the investors, making sure that the job count is appropriate relative to the economic analysis and business plan. Also a very important responsibility, that is preparing and filing the Form 924A, the annual reporting that has to be done with immigration, and that is between September 30th every year. Last August, September 30th, it's 90 days, not 3 months, so I shouldn't talk about 3 months. People often make that mistake in immigration. When you have 30 days to reply, that is not a month. Again, responsibility to prepare the packages. That is the application to remove the conditional nature. Now, 829 is somewhat like, if in fact 829 is denied, the poor foreign national, yes, they can file a motion to reconsider, but the poor foreign national and their family will simultaneously receive a notice to appear in immigration and appear for removal and deportation hearing. No fun at all. Even if the denial is 10 or 15%, that is a very, very high statistic for the poor folks who end up in removal proceedings. You do want to make sure that you get this right. Now, regional center versus direct, I used to say about 90% of cases were in fact regional centers. That's going down, of 526s. That's probably going down as the direct or standalone program becomes more popular. The benefits of investment through a regional center are quite considerable, including the creation of or the ability to count indirect jobs. So a particular regional center may affiliate with a particular investment project. It may also be pre-approved by USCIS, the so-called exemplar. That is now of dubious value, because the 526 approval with the new deference policy effectively counts exactly as an exemplar would. So no point in delaying as of the present time. But of course, a regional center can file an exemption, which will give some confidence to potential investors that the project has already been approved. So that is one of the big advantages that you can do with the regional center, not in the direct filing, only in the regional center context. But the approval of the first 526 effectively does the same. And is point mentioned there requirements is not about the reason why regional centers have become so popular because they do allow for the counting of indirect as well as direct jobs, and our economists will explain that in further depth. Investors can take a less active role. They do not need to directly involved in management. They can be involved in policy decisions, and that allows them considerable freedom, both from a technical point of view. They don't necessarily have to be involved in day-to-day hands-on operation of the business and merely are involved in policy formation. Apologies again for my somewhat squeaky voice. Seem to have picked up a little bug on my trip to China. Just got back last week. So a regional center affiliated project can count both direct and indirect jobs. That's the big one, and that's the reason why, in fact, regional centers are so popular at this time. Now, we're moving on to explaining indirect jobs. Aaron, get yourself ready. I'm going to dump this one on your shoulders with the squeaky voice and the audience an opportunity to hear a normal expert talk that is a normal sounding expert, normal voice sounding expert explaining indirect jobs. So tell me, Aaron, explain a little bit about indirect jobs, indirect job creation, multiplier tables, feasibility studies, market analysis, and economic or statistically valid forecasting devices. Take it away, Aaron.
Yeah, very good. Thank you, Bernie. So to your point earlier, one of the real valuable approaches of using the regional center context is that you get to include indirect and induced jobs in your total job count. And the benefit of that is that you can have a larger percentage of the capital stack come from EB-5 direct investment. So that being said, if you think about indirect jobs, it's really just the downstream impacts that your project's going to have. So if you're having a hotel, for example, you get credit for the employees of the hotel, but those folks are also going to go into the community and go to the grocery store. They're going to additionally spend money at the gas station. There's going to be downstream impacts in supply chain for that new commercial entity, or the job creating entity rather. And from that, you get to claim those induced and indirect jobs. And USCIS and The Economist have looked at what a reasonable methodology would be. And typically, you'll see RIMS or INPLAN or Radine or other methodologies utilized to factor in these downstream impacts in the community. So that's kind of at a high level the advantage of the regional center and how indirect jobs are calculated. As it relates to feasibility studies and market analysis, we'll discuss in a little bit more detail later, but ultimately USCIS just doesn't want to take the developer's word that this project would be viable or that their inputs are reasonable or practical. They want to see third-party data that suggests that your forecasts are in line with industry standards and are supported through quantitative data. And this is really important not only from a USCIS approval perspective, but since it's predicated on this job creation, I think the investors are well off to know that these projections are reasonable and within industry standards.
Aaron, very helpful, thank you. And we are going to go into the weeds a little bit more, talk about RIMS 2, INPLAN, and Redine. I will briefly talk about what is the role of the Immigration Council. I know many of lawyers online. One of the requirements, of course, or roles, and there are many roles here, advising developers of the options in terms of structuring, setting up, creating, basically being the quarterback, general manager, and putting the whole package together. One of the things we do as immigration lawyers is put the team together. I'm proud to point out that many of the participants today are in fact the go-to people that I work with. Aaron Goforth, president of Wright Johnson, BPs, business plans, economic analysis. Haven't had the pleasure yet of working with Elliot Winer, but I do understand he is the absolute guru in the area of TEA analysis, which is one of the most important components if you want to get down to $500,000, the reduced investment amount, and that's quite frankly where you need to be. Jor Law, our resident expert in the securities arena, setting up corps, setting up structures. Jor, absolutely, Homeyer and Law, total winners in this particular arena. And last but not least, Michael Gibson. Michael has, in many respects, defined the arena in terms of due diligence. There are people out there who are afraid of Michael Gibson, and maybe for good cause. If you are doing things that are inappropriate and expect Michael Gibson to find out about it. This is the man who does due diligence. He does it well, and I am proud to say is one of the people that does keep the industry, helps keep the industry fresh, and is absolutely defines the criteria in terms of due diligence. Preparing and filing a regional center application, another critical role, preparing and filing applications for project pre-approval. I already explained, perhaps less valuable than previously, but certainly useful in the marketing context to have an exemplar approval, and filing EB-5 petitions for the investors. That is a critical role. Now, let's move forward again on how to create a regional center. I'm going to throw this one back at you, Aaron, just because my voice is gone, and you can fill us in on some of the steps that are taken. Wright Johnson, absolute experts in this arena, prepared literally hundreds of economic analysis and business plans in this area, critical for the regional center, and absolute experts in this area. So, Aaron, fill us in. What are the few steps that one would take, and what sort of evidence do we need besides our $6,000+ government filing fee in terms of putting together a regional center application?
Yeah, it's a very complex and process. And to your point earlier, the immigration attorney is really the focus to help understand the client's needs and set out kind of the long-term and short-term strategy for the application itself. At a macro level, kind of 30,000-foot view, you need to focus on what geographical area and industry sectors you want to focus your application in on. Some of that has a different meaning today than it did previously, but you need to understand what is your objective as a regional center. Are you trying to specifically fund one project, or do you want to have a more broad approach where you're going to be a vehicle to find projects in the future to raise capital through the EB-5 program? So once you've kind of aligned to what industry sectors and what geographical area you'd be interested in, then from my perspective, you need to take a look at what projects are going to support the filing. So the regional center application does need to be attached to a project-specific business plan and economic analysis. Now, based on your goals, you can take a couple of different approaches, whether it be an actual or exemplar, where you have kind of the shovel-ready details, or more hypothetical, to get the regional center approved. In that, job creation really is critical. So, you know, economists can do a preliminary analysis to determine, you know, based on your project, for example, assisted living, you know, how many jobs you're going to get from construction, how many jobs may you get from operations, whether it be direct, indirect, or revenue-based. And then once you have that, you can kind of structure your deal. Additionally, at the time of the individual 526 petition, you're going to need a up-to-date TEA designation, and I'm eager to hear Elliot's discussion later on this conference. But going into the application, it's probably a good idea to make sure that you know if this will qualify for TEA and will it qualify in the future. So once you know your area and you have a business plan and economic analysis to provide the evidence that USCIS wants to see for the project, from my perspective, the business plan and economic report are kind of really the big antelope in the process, but everything is absolutely critical in the regulation. Bullet 3, the promotional activities and budget, I like to think of this as the business plan for the regional center. So USCIS wants to see that you've thought through how you're going to go market these projects, that you have a budget in place and ensure sustained operations of the regional center. And then additionally, whether they be customized or more of a template version, something like Jor Law can help you with the transactional documents that you'll need. So the PPM and the different offering documents, whether they be deal-specific or more generic, USCIS wants to see that you actually have the capability to go raise capital and that you're doing it in a way that's compliant in the spirit of the regulation. And then finally, you need to kind of map out ahead of time to USCIS how you plan on you structuring your deals. Are you going to go to the loan model, or are you going to do more of a direct investment structure? And experts like Jor and Michael Gibson can speak more to some of the thoughtfulness that needs to go into those documentations and how you want to think about that on the front end. So that's kind of my macro perspective. To jump into the weeds a little bit on the geographical area, from an economic perspective, I think this is important. Typically, you can ask for areas that you are going to show economic impact in. So if you have a assisted living project and it's in, say, the greater Chicago metropolitan statistical area, by definition, a metropolitan statistical area is an area that's economically intertwined. So you could request that piece of dirt, per se, in your USCIS application. Another approach would be to look at individual commuting patterns for a project. So if you have a project in Grand County, Colorado, perhaps there's people coming from Summit County, Colorado to work at that job-creating entity. And if that's the case, you can make a statistical-based, economically sound request to have that region incorporated. So going on to the next topic here, because of interest, that when you have a project or you're thinking about preparing a regional center application or putting a project underneath an existing regional center, you may want to think through what's going to be the most effective approach for you. So again, going back to the commuting pattern approach for the geographic area that you may want, you could also look at the metropolitan statistical area. And then you need to balance maximizing your geographic reach with the ability to provide very succinct, reasonably supported business plan and economic reports to gain the regional center boundaries that you may want to have. So it's really kind of a front-end decision in terms of how large of a scope you want that initial application to be and your ability to provide reasonable projections to support that claim.
Aaron, it used to be that we had 6 months ago huge problems with NACE codes and defining our industry sectors. Apparently, post May 30th memo, that's out the window. Talk to us about that point, sir.
Yeah, I think it's a huge breakthrough for the program, frankly, is that folks would be submitting multiple industry sectors just so they have the ability to raise capital in those sectors. So you might have an application that would have a hotel project, assisted living, and a fish farm. Just in the future, if they ever want to find capital for a fish farm, they want to have that business plan in there. But now I think it's going to streamline the process that, based on the May 30th memo, you're no longer tied to the industry sectors that you're approved for. And the new approval letters even state that amendments not required. So basically, bottom line, from my perspective, what that means is once you're approved regional center, if you can find a viable project, even if it's outside your original industry sector approval, you can go raise capital for that project if you can put the appropriate documentation in order.
Well, thank you very much. Talk to us a little bit about the business plan and job creation.
Yeah, the business plan, we really need to sure we're thinking about the audience here. And the audience is USCIS adjudicators. And there is case law, which is a matter of hoe, to demonstrate very specific details that USCIS wants to see. And, to sum it down, we need to have reasonable projections that are based on industry standards that go into not only the job creation for the economic report, but also support the viability of the project as a whole in the marketplace. And I think we've seen since the May 30th memo that in some regards, whether it be a hypothetical project, it seems that perhaps they are loosening their review and general practices and forecasts will work. But I do think for that exemplar and even for a hypothetical project, frankly, the more third-party data you have to support it, the better.
And operational and marketing plans?
Yeah, so going back to kind of our 30,000-foot view, this is your business plan for the regional center, if you want to think about it that way. So you're demonstrating in USCIS that you kind of understand the nuances of the program, what they want to see from you in terms of marketing your projects or running the regional center, and then you're going to do the appropriate operations and balance in terms of reporting and ensuring that you're doing things in due order so that you have a positive outcome not only for the project, but as equally important is for the individual investors, so that you have all the appropriate documentation and process in place to be a successful regional center.
So this is basically the business plan for the regional center itself as opposed to the specific business plan for the project. Two completely different animals, correct?
That's exactly right. And that's the objective here, is how are you going to, as a regional center, do business and support individual projects. So the application itself for the 924 requires both the business plan for the project, and then as I like to think of it, is the business plan for the actual regional center.
I'm going to jump in here and bring Jor in, even though this is one of your slides, to talk to us a little bit about organizational and transactional documents, because this is an area, Jor, that you're very active in as well.
Right. There are essentially, a couple of different types of documents that you'll need in setting up a EB-5 offering in regional center. And some of them are kind of the standard corporate transactional documents, such as setting up a company, the incorporation, the articles, the certificate of formation, and things like that. And those are really your organizational documents. Your operating agreements and your bylaws and things like that are typically the organizational documents. And those are documents that you would have to set up anyway, even if you were not doing EB-5. It's just that in EB-5, going to a standard corporate attorney or trying to do it through LegalZoom or something like that, it wouldn't normally be recommended, because sometimes there are quirks to those organizational documents that are necessary for EB-5. And the standard document might lead to a RFE or denial at the USCIS stage. Now, those are organizational documents. The subscription agreement is actually part of the offering documents phase. And the subscription agreement essentially is an agreement whereby someone says that I hereby will buy X shares of your company or X units of your company, and that's an operative document for the purchase of the securities. Of course, the escrow agreement, everyone knows what that is in EB-5. That's typically an agreement that's holding the investor's money until a certain event has happened, either a accumulation of I-526s have been approved, or until the investor's I-526 has been approved, or any other factor that, maybe minimum raise or things like that.
Jor, let me jump in here on escrow agreements. We're seeing more and more early release escrow agreements. Is that the pattern? And then, Michael, just to bring you in on that, what are your views on these early release escrow agreements, particularly if the project were to fail? Jor, any comments?
Yeah, it's kind of, escrow agreements are, generally, they're mostly for the protection of the investors, and in most cases, they're kind of a nuisance to the company that's raising the money. So there really should kind of be a balance between the two. If you have an escrow agreement, I guess that's, too investor friendly. That's really great for investors, but that could present a hardship for the issuers. I tend to prefer, as a personal preference, I tend to prefer a more conservative escrow agreement that is protective of an investor. But on the other hand, our firm typically represents companies that are raising money, and my views no longer matter. It's only our clients' views kind of matter. we're seeing an increasing trend of clients that don't want to wait engage in best practices in waiting for each investor's I-526 to be approved before releasing money. More and more of them are doing some sort of early escrow release, and in some cases that's okay. Some of the projects, they're backed by very strong and reputable folks, and if something goes wrong, they certainly have more than enough money to pay back. But for some projects where the issuer is not quite so strong, that's definitely a risk to the investors, and we, in any case, whether the issuer is strong or not, it's a risk we typically will disclose in offering documents.
And Michael, what's your due diligence take on this particular point?
Right. First of all, let me apologize. I'm on a cell phone, so if it's not clear, I apologize. We're doing a site visit right now of several projects. I'm in California. I agree completely with what Jor said. If the project is strong and it has a lot of very strong fundamentals, as well as a competent development team, and it is economically viable, then escrow is not a big issue. In fact, it could be detrimental to the development of strong projects, because most developers will tell you they simply cannot wait a year to 2 years for the funds to be released. So the highest quality projects are not going to wait that long for the EB-5 capital, even if it is only a component of, say, bridge finance. So Jor is exactly correct. The strong projects don't want to wait, and they shouldn't. The problem becomes when the client's funds are released from escrow, or if in the case where there is a partial escrow or no escrow at all, the funds are released and they go into a project which subsequently fails for any number of reasons, then the investor has very little recourse, and I think that is the dilemma. So in strong projects, it's not necessarily a necessary component, but in the weaker projects, it's probably advisable.
Michael, thank you. And just for those of you who are immigration lawyers, determining a strong versus a weak project is obviously the name of the game. It's not an area where we as attorneys should be opining because of the securities element. Michael Gibson is the person to go to, who is a registered financial analyst, qualified to provide this type of analysis. We've spoken very briefly about the offering documents, the PPM. By the way, this is the third in our four-part series. We will take a little bit of a break. The next one is in November, but all of our prior programs are in fact recorded and available on our website at wolfsdorf.com, WOLFSDORF.com. There it is on the screen. If you want to pick up some of the earlier ones, one of them was not recorded. I encourage you all to get on and make yourself familiar with some of the more basics if you're new to the game. We're going to get more and more complicated as we go into the weeds, particularly in the next one. So anyway, coming back to our topic, Jor, fill us in. We mentioned earlier what the offering documents are. What exactly do we need to include in our package?
The offering documents is really a combination of a few of the other documents. It's essentially, what constitutes the offering. The offering is issuer, company A, am going out to raise money. And all the documents that I use to go raise money, they collectively turn into the offering documents. The slides are dancing around right now, but
yeah, no, I'm playing with them. I'm playing with the slides. Excuse me, folks. I was trying to find yours. There they are.
Yeah. So the offering documents, typically in EB-5, comprise of a combination of these documents. Of course, first there's the corporate documents, that I've mentioned already as the organizational document. Then the offering documents themselves are typically investor questionnaire, the subscription agreement that talks about the, that whereby someone actually purchases the securities, and then there's a private placement memorandum or offering memorandum. I left out the escrow agreement in this case, but that actually should be in there. The regional center documents are often included as part of the offering memorandum package, or at least alluded to, although they're technically not part of the offering documents. And the regional center documents typically would be some sort of agreement that shows the link of the regional center to the company during the project. In some cases, if the regional center wholly owns the project, there wouldn't be a need for a services agreement, or if the regional center itself was raising the money. There are other documents that investors would typically want to see, and those could be the loan documents or other investment documents. And those could actually either be summarized in the PPM or attached as exhibits in the offering package. There's various ways to accomplish this disclosure.
Thank you so much, Jor. Talk to us a little bit about equity model structures.
Yeah, the equity model structure, when it's applied by a regional center, typically looks like this. There is another variation whereby the capital raising entity that you see in the middle here is actually the same as the regional center. But for most deals, the regional center will set up a special purpose vehicle, or a regional center will provide services. In this case, you see the word sponsors, but the immigration attorneys hate the word sponsor. So they provide services to the capital raising entity. And essentially, the capital raising entity is the one that goes out and gets the investors. This slide kind of got, the formatting on it, I guess, got lost in translation. But the boxes on the left and on the right are supposed to be investors that are investing into the project company. And then the capital raising entity is also the project company. And therefore, the investors that are investing, they're getting equity in the project that is in a company that creates the jobs. And this is what's traditionally known as, the plain vanilla equity model in the RC structure. This slide, it talks about the indirect equity model, or more commonly the loan model. They're two different things, but this structure is more seen in a loan model situation than in indirect model situation. And it's basically identical to the last slide, except for there's one extra step. The capital raising entity in the last slide, which happened to also be the project entity, now is split into two. The capital raising entity that goes out to raise EB-5 money does nothing. They have no business other than to raise money and then make a loan or make an investment to a project company. And the project company is where the jobs and where the assets and primary collateral for a loan and operating business, that's where everything, all the gold and the good stuff is. So in this case, they call this the loan model typically because typically when you do a loan model, you do have the investors coming into equity first of the capital raising entity, and then that capital raising entity in the middle then kicks out a loan over to project company.
Well, Jor, thank you so much. We really appreciate it. I know you have to run. Jor's the go-to corporate and securities lawyer that I work with. He certainly knows his stuff when it comes to setting up companies, focusing on the appropriate structure, preparing PPMs, private placement memorandum, and ensuring that we, in fact, are complying with securities law. So Jor is the guy to go to. There we go. Contact information for Jor. Excuse my, what I'm going to call jumpy fingers as we go through various slides. And now, for those of you, we have our special guest, Elliot Winer. Thank you so much for joining us. It's truly a privilege and an honor to have you on board. Understanding targeted employment areas, we have Mr. Elliot Winer from Sudbury, Massachusetts, Northeast Economic Analysis, LLC, There's his telephone number. There's his email address. You need to get an answer on your TEA question. This is the gentleman to reach out to, the absolute expert. And my apologies again for the squeaky little voice I have today. Must have picked up a bug. So, Elliot, please take it away.
Hey, thank you. Good afternoon. And I hope everybody can hear me okay. I had a problem earlier with the audio connection, but I'm assuming that everything is okay right now.
Loud and clear, Elliot.
I'm going to try to demystify the whole process of the target employment areas. So to begin with, there are two types of target employment areas, or TEAs, and that's what everyone is interested in to get the reduced $500,000 investment. The first one I'm going to refer to, the first type of TEA, the one least commonly thought of is the rural area. This is oftentimes overlooked, but an important source of TEAs, and it presents many good opportunities. However, what people think of as a rural area does not necessarily comply with the EB-5 definitions of rural. Just because an area or a location happens to have farms or open lands and to your way of thinking looks like a rural area does not necessarily abide by the EB-5 concept. Specifically, to be a rural area for EB-5 purposes, the area must be in an MSA, a metropolitan statistical area. And what an MSA is a county or a group of counties, except in New England, which operates on its own set of rules where I'm located. In New England, it's based on the city or town concept. But in the rest of the country, an MSA is a county. So if your county is in an MSA, then you cannot be a rural area, no matter how rural that area might look to you. But in addition to not being in an MSA, you also cannot be in a city of 20,000 or more population. So the two things to consider for rural are you're not in an MSA and you're not in a city of 20,000 population. But just as I mentioned that it can be misleading that you can think you're in a rural area when you're not, conversely, you may very well be rural for EB-5 purposes, even though you don't think you are. You can be located in a small town or a city or industrial area that you wouldn't think of as rural, but because that population is under 20,000, according to the latest 2010 census, that you'll still be you can still be considered rural as long as you're not in an MSA. Now, but the final point on rural, which is oftentimes confusing, states are not authorized to designate a rural TEA. This makes absolutely no sense, and I can't tell you why, but this is the case. The state did not give an official designation of a rural area. Some states will provide listings of rural areas so you can use those, but you have to supply the evidence yourself according to EB-5 definitions that the area is rural. So you cannot get a letter from the state, you cannot get a letter from anybody officially to designate an area, but you have to supply the evidence that authorizes, that says that that area is a rural TEA. Okay, now let's go on to the more common, obviously, TEA definition, the high unemployment area. High unemployment TEA simply is an area that has 150% of the U.S. average unemployment rate for the comparable reference period. Now, what is the comparable period? Different reference periods are used. The most common period would be the annual average, or the most recent annual average. So, for example, 2012, U.S. annual unemployment rate was 8.1%, and 50% of that would be 12.15%, or rounded up to 12.2%. A few states round down to 12.1%. As you'll find as I'm going through this presentation, each state kind of has their own thing, so there's differences from state to state. Many states, however, do not use an annual average. They use a fiscal year average, a July to June average. So for states that have updated to the July to June 2013 numbers, they'd be using an annual unemployment rate of 7.8%, requiring a 150% rate of 11.7% or more. And then there are a few states that use a 12-month moving average. And my own state, Massachusetts, is one of those states where the rate will change every month. It'll be more up to date, but right now they'll be using the latest information. So they would be using September 2012 to August 2013 basis. Next month they'd be updating, dropping 1 month, adding the next month. So you have to be cognizant of what time period a particular state is using. Now, another misconception that people have, oftentimes I'll hear people say, well, the unemployment rate is dropping, that's going to make it harder to get a TA. Well, that's not necessarily the case. All that really matters is how your state or your area or your individual location is changing in relation to the U.S. because the important criteria is 150% of the U.S. average. So if the U.S. rate is dropping, and your state is also dropping, but dropping at a slower rate than the U.S., then your TA possibilities are actually going to be enhanced. An example of this would be 3 of the states in the Northeast would be good examples. New York, New Jersey, and Pennsylvania. The rates in all 3 of these states basically stayed the same. They might have gone up or down very marginally between 2011 to 2012, whereas the U.S. unemployment rate dropped from 8.9 to 8.1. So what happened was when these states shifted to the 2012 annual basis for the calculations from 2011, the TA possibilities increased quite a bit. Many areas that were not eligible before now had the possibility of gaining TA status. Conversely, many other states around the country, specifically states like Florida, Arizona, Michigan, and Ohio, where those rates drop faster than the U.S. average, it has become much more difficult to get TAs. So areas that may have qualified in 2011 that may very well not qualify using the 2012 numbers. Sources of information that states used. The Bureau of Labor Statistics, as well as the states themselves, will publish official estimates. So official estimates are available at the state, the MSA, the county, and large cities of 25,000 and above. And for New England, for all cities and towns. So if you're in one of these areas, state, MSA, county, city, you can just go to the Bureau of Labor Statistics website and find out what the rate is. However, in most cases, those areas are not going to qualify automatically as target employment areas. The only state that qualified last year was Nevada. So in 2011, anything in Nevada qualified as a TA. That is no longer the case in 2012, and no other states qualify automatically. For MSAs and counties, there are some that do qualify as high unemployment areas, but a very small percentage. And likewise for cities and towns. There are some that do. In most cases, the areas you're looking at are probably not going to qualify as a whole. The next step that we go down to a sub-geographic level, a geographic or political subdivision. And the important concept here is the area has to be contiguous. So if you're using census tracts, which is the logical basis for the geographic or political subdivisions, these census tracts have to all be contiguous. They have to touch, the borders of one census tract have to touch. You can't jump from one location to another. So the census tracts is the primary source for these subdivisions, but some states will also allow the use of block groups, which are essentially components of census tracts. Okay, what do you need to get from a state to get TA status? The states obviously are authorized to designate high unemployment TAs, and that's what is done in most cases. You can go directly to USCIS, but that is definitely not the advisable course of action, just because of the length of time it would take. Whereas you go to the state, you're going to know, probably within a matter of weeks, whether that area is going to get a TA designation. So you get the authorized letter from the state, with the exception of Texas. Texas is, there is no state authorization in Texas. In Texas, it is all done at the local level. Each mayor of the city and our county judge of each of the counties has the authority. So Texas is like a mini U.S. where many different cities and county judges have the authority, and they may have their separate rules that they go about in doing the designations. The USCIS will now defer to states. This is something as a result of the May 2013 memorandum, which now clarifies that if you get the state designation, the USCIS will defer to that state designation, even if they themselves may not have approved it on their own. They may not go along with it. The USCIS definition actually is much more strict than what it is in most of the states. And they advise against things like gerrymandering, but on the other hand, they do not have a specific policy, and they do leave it up to the states as to how they want to interpret the definitions. So they will abide or defer now to what the state designates as the TA. However, they do reserve the right to ensure that correct methods are utilized. So by correct methods, in other words, they will check to see if you applied an approved Bureau of Labor Statistics BLS methodology. You just can't use any methodology and say that, hey, this city did their own estimate and the unemployment rate is 15%. That's not acceptable. It has to be an approved BLS methodology, and you have to use the latest, basically the latest numbers. You can't pull out numbers from 2009 or 2010 and say here's a qualifying number at that time. It has to be recent numbers that are being used. And finally, you have to, they will check to make sure the calculations are correct. You can't just throw numbers out at them and say this is the number. You have to have the evidence, or at least have the background information to be able to show if they question the numbers, how were those numbers derived.
Well, Elliot, thank you so much. For most of us lawyers who have to take off our shoes to count beyond 10, because we're still counting on our 10 fingers, we really appreciate your in-depth analysis. The other ways we can answer that million-dollar question, or should I say $500,000 question, is we can simply reach out to you and say, is this particular address in a targeted employment area? So we really are very fortunate to have you today. And for those of you lawyers who are getting confused, I'm going to ask you to actually go into the weeds just a little bit more. You have already done so to some particular degree. Let me make sure I have all my slides in place. And we're going to just fly through these various technical slides that you have.
Okay, so I had mentioned earlier, and this is very important to understand, that they said 50 states, 50 different approaches to TAs, and this isn't an exaggeration. This is literally correct. Each state has its own rules, procedures, policies that they go by, and there are variations. So I talked about different reference periods. There's different implementation dates when they update. Some states might update their annual numbers when it's available in March or April. Others don't get around till maybe June or the fall. Same thing for ones that are doing the fiscal year basis. Sources of deriving the estimates. Some states use, the BLS I mentioned is the official source of the current data, but in doing the methodologies, some states use the Census 2000 data to disaggregate. The majority of states still use what's called a special 2000 household adjusted tabulation, which is a 2000 census data that was adjusted to correct for a flaw in the 2000 data that overestimated people living in group quarters or college dormitories, which exaggerated the unemployment rates in college areas. And therefore, they advised to use those numbers rather than the straight 2000 numbers for disaggregating your county estimates. A lot of states right now are gravitating to the American Community Survey data, but there's still only maybe 12 to 15 states that are using these 5-year estimates. It's more current information. Some states still aren't as convinced of the reliability of that data, but more importantly, a lot of states are waiting for the Bureau of Labor Statistics to institute the ACS and their other statistical programs. The bottom line, however, is that the USCIS will accept either approach, whether using Census 2000 or ACS. It's just a question of which procedure the state is using in applying the methodology. And final bullet point under there, the Census 2000, a lot of people think, why aren't we using 2010 census data? The reason is the 2010 census data does not exist at the level we need it at. That information was collected in 2000 on the census long form, which was thrown out with the 2010 census. So employment and unemployment information at the micro level, at the sub-county, sub-city level, is not available from the 2010 census. That's why your options are limited to 2000 census or ACS. The next point I'll just go through quickly. It gets a little technical. Again, there's different ways that states disaggregate the data. They might share out or do a census share methodology out of the entire county. They might do it out of a combination of published cities and what they call a balance of county. They may do it out of published cities and the entire county. And in New England, which again is different from the rest of the country because county government really has no real concept in New England. In New England, every city and town is published, so the disaggregation is done out of each city or town, no matter how small it might be. And then finally, on that slide, some states will use block group data, which definitely increases the chances of getting TAs. But larger states will generally not use block groups because it greatly will increase the potential workload of staff involved because it opens up innumerable possibilities. Smaller states sometimes are willing to do it because it gives them more opportunity in rural areas to find TAs where they otherwise might not be able to do it.
Elliot, if I can just jump in at this point,
Yeah.
just using my very simplistic analysis, so New England got its own special way of doing things. I used to live in Boston, and that doesn't surprise me. Texas, similarly, has a different framework, not the state, but individual county judges can even set a TEA, so cities can set a TEA. And then, of course, in California, it's relatively easy because the state, in fact, will do the job for you and provide a TEA determination. Is that more or less accurate?
Well, you're correct. In New England and Texas, Texas, they kind of got grandfathered in because they originally, it shouldn't have been that way. The authority is supposed to go to the state, but somehow initially your authorization went to the local level, and apparently the USCIS let them get grandfathered in and keep it that way. In California, California had been very difficult to do last year, but they opened things up quite a bit where they do allow now a combination of areas, but there still are some constraints. It's not completely open-ended. They limit it to a maximum of 12 census tracts. You can't go any higher than that. So if you can work your unemployment, if you can get a qualifying rate within a group of 12 tracts, you can do that. But California also requires you to get a local support letter. That's another step, which frankly is a good idea, although it does complicate matters, and make sure that the local county or city is tied in and that they approve the concept and that they believe that the employment and potential employees will be drawn from that immediate area. So if the local community had a problem with the investor group, or they didn't think that it was a reasonable area, they can refuse to provide the support letter, which is needed before you can go to the state with the application process.
Elliot, thank you. With the May 30th memo, the question is now, it appears that we can, in fact, go beyond the scope of the approved regional center to include contiguous territories. Can you explain exactly how this may work in real terms?
Well, for TEAs, it's still it still doesn't really change things as far as everything is done at the state level. What you're referring to is more the regional center itself can go to expanded areas. But the TEA is still going to be based on the state rules and regulations. So if the state has specific criteria, there's one state, for instance, in the south, which only will allow TEA on an individual census tract. So you can't do anything in that state, even if you have a high unemployment all around the area. You cannot get a TEA in that particular state unless you're located in that particular tract. Whereas other states I mentioned are open-ended. You can string together anything that will work, and other states are in between, like California, will allow, like I said, up to 12 tracts. So it kind of varies from state to state, but you still have to adhere to whatever the state procedures and rules are in defining the TEA.
Elliot, thank you. I had a recent situation where I had to file a bunch of I-526s by the end of the month because there was advance notice that the particular project would no longer be in a TEA area. So even where one presumably thought they had a lock-in, one can have a situation where that area is no longer a TA and the qualifying investment may in fact move from 500 up to 1 million. Have you seen that situation, and can you explain a little bit further how that happens?
Yes, definitely. That's a very good point. And actually, I was going to be bringing that up at the end, but that is a very, very valid point, that the TEA definitions are generally good for 1 year. There's nothing in writing on this, but rule of thumb is that the USCIS will accept a letter dated within the past year. And states, as I mentioned before, will update the numbers at various points during the year. And a typical timing period would be like around March or April. So prior to that update taking hold, as an example would be like if you were in Florida or Michigan would be one of the states, and you had a rate last year that just qualified, I could have determined for you in advance, in which I did in a few cases, for people and tell them that if you still need that certification for the next year, you're not going to be able to get that come April 1st when your state looks at new data. So in those cases, you might want to try to jump the gun and get a certification prior to the expiration date, or see if you can get it recertified if the state will allow. Oftentimes, an area, a TA could still be expanded by just expanding the area. So you might have an area where, let's say there was 4 census tracts that had a rate that was approved last year, or even this year. And come 2013, when the new numbers are going to be published, I could determine that that area will no longer qualify. It'll just miss out. But potentially, you may be able to go back and add another track or two, maybe make it a 5 or 6 track combination that will now qualify. Whereas if you were stuck to your same 4 tracks, you couldn't make that qualify in that regard. A classic example would actually be what happened in California, where City of Los Angeles, City of Long Beach, San Bernardino County all automatically qualified in 2011, and I knew by the first of the year that those would no longer qualify when they updated in May 1st. And so people who relied on that could have been out of luck. However, fortunately, California relaxed their policy and allowed for sub-area determination. So in most of those cases, those areas that did not automatically qualify, we could still go back in and get a qualification. But you do need to be cognizant of the fact that your area may very well not qualify next year. And as everybody is well aware, usually with TAs, you're looking for more than a 1-year period. To get the investors in, it's going to drag on for a longer time frame. So oftentimes having a 1-year certification guarantee may not be enough.
Perhaps from a simplistic analysis, losing TA designation halfway through a project could have a devastating impact if that project is being marketed at $500,000, and it's certainly difficult to market at the $1 million area. Elliot,
So what I'll try to do in those cases are, if you can do it, and occasionally you don't have any other option because you can just barely get the qualification, but generally you try to create, in creating the TA, you try to create a little bit of wiggle room to not make it just qualify, or at least if you don't have the wiggle room, at least to know that if next year the rate was lower, we would still have no problem with an expanded area. We could still make the area larger. So that's why I always try to look at that in making the TA, so somebody isn't going to get blindsided next year and find out all of a sudden that area will not qualify.
Well, Elliot, you've certainly helped us demystify the TEA analysis. You've reminded me about something I've always known. The analysis is very complicated. This isn't something that immigration lawyers should try at home with their pocket calculators. They may well miss. And that brings us to our final speaker today, Mr. Michael Gibson, a registered investment. There are many people who claim to be experts in this particular arena. If they do not have a FINRA, F-I-N-R-A card with an appropriate designation, they are blowing hot air, and they are not the correct person in terms of undertaking risk assessment. Now, Michael's presentation here focuses on issues of marketing in China. Probably at least 80% of the EB-5 market is currently focused towards China, where this program is, quite frankly, red hot. One of the issues that we'll focus on is the question of whether we're going to be oversubscribed in the future, with some 6,000 families, that is 6,000 cases pending at the California Regional Center, and potentially another 7,000 or 8,000 being applied for in the upcoming 12-month period. We're looking at 10,000, 15,000 families applying for only 10,000 visas. My math is no good. Unfortunately, I put my shoes back on, so I can only count to 10. But the simple bottom line is we may well have an issue, or a CISPA age-out issue, in regard to children who may be over 21. To summarize this in a one-liner, it's not part of our topic today. If processing times are only 1 year, 526 processing times are only 1 year, and the individual has 2 years to go, as it were, before they turn 21, there isn't going to be a problem. However, if processing times increase, that will actually be beneficial. Boy, I've probably lost my audience. But if processing times increase, that's actually beneficial, because you can deduct the time the 526 was taken in terms of processing from the foreign national derivatives age, that is the kid under 21, in order to obtain CISPA protection, provided that petition was filed prior to the child turning 21. Now, I have done an article on this that will be published shortly. Those of you who have interest, email me. I can talk to you about age-out issues. But I now want to switch over to Michael Gibson, who is going to focus specifically on problems and issues associated with marketing in China. Michael, take it away.
Hi, thanks so much again, Bernie. So, yes, I was actually in Beijing last week, and I was addressing a large number of the migration agents, and they had invited me to speak to their association to address what they were concerned about, which was the increased number of failures that we have seen not only this year, but in the past few years, with projects being presented to them. And my talk to them covered 4 aspects, but for today what I'm going to discuss with the audience is the second one, and this is basically why EB-5 investments are going to have a higher default rate than your traditional investment. And if you know, with any investment, whether it's into real estate or commodities, equities or bonds, typically there's only 2 outcomes. With EB-5, there's actually 4. With the traditional investments, the value of the investment will either increase or decrease. But with EB-5, and if you advance to the next slide, you can see there's actually, these are the adjudication rates right now and the approval rates. These are for the 526s and then for the 829. Both of them are around 80%. But if we added the USCIS conditions for possibly not approving the removal of conditions at 829, combined with the historic failure rates for businesses in the United States, you're going to get a set of probabilities, the mathematical probabilities. These are the survival rates for companies, and one thing you can see is that for each year, there are fewer and fewer businesses than were the previous year. So after year 4, this is from the Bureau of Labor Statistics, we can see a 44% survival rate. We can also estimate that as year 5, 6, and 7 come in, the actual rate is going to decrease, but for argument purposes, we're going to use that 44%. You can also see that regardless of the industry, of the asset class, the survival rates year by year decrease. So regardless of whatever your client has invested in, the chances that the business will survive decrease year by year. So let's combine the knowledge that not all 829s are approved and not all businesses will succeed, and these are the mathematical probable outcomes for the typical EB-5 investor, and we can see that the first outcome, which is the most hopeful for everybody, the actual probability of success to achieve both the 829 conditions removed and full principal return is actually only 35% of the time. So we can make a general assumption that in all EB-5 cases, after the exit, after the term has expired, let's say in the next 5 to 7 years, probably all of the clients who have petitions right now and capital invested, only 35% of those will be successful. The rest will vary. Some will have 829 denials, some will get the full principal return, or a combination. They may have the 829 denied, they may not get the full principal. This is the breakdown. But mathematically, what we can see is that 3 of the 4 outcomes, as we discussed in the very first webinar, are negative for EB-5, and these will occur about 2/3 of the time. So for all of the people listening, you could just estimate if you have 10 or 100 clients in there, you can probably, as a rule of thumb, estimate that about 1/3 of them will be happy, about 2/3 of them may not be happy. This is a graphical representation of the overall success. So again, about 1/3 of the cases will likely result in a very positive outcome where both the 829 is approved and they achieve their full return of principal. Okay, so this is the breakdown again by category, and if we advance one more. Okay, so this is again, if all your client cares about is getting the conditions removed, then 80% of them will be very happy. If they don't care about the return of principal, then your 4 and 5 are going to be very happy clients. 1 and 5 may not be, but 4 and 5 are going to be, which is pretty good. But if you add in the risk of failure to exit and achieve full return of principal, if you can advance, you can see that the failure rates, the investment loss is actually over half. Investment repaid is less than 50%. And again, the overall outcome, the most probable outcomes for EB-5 investment is that 1/3 of the clients that you have right now who invest in EB-5 are going to be happy. About 2/3 may not be so happy. Okay, and then if you continue to the next question then you should ask if you are an attorney, an immigration attorney filing petitions for your clients, is that not all of the asset classes are equal in risk. So the question should be, if I know that 2/3 of the investments may fail, then I would want to make sure that my clients are in the safest asset classes. And we have a breakdown of the risk associated with different industries and different asset classes in the next slide. And you can see, now this is the closest that we can use to the private equity world, which is corporate bonds. And we can see the default rates by industry and which industries account for the highest default rates among corporate bond issuances. And these are, unfortunately, many of the most favored investments for EB-5 purposes. It's not a coincidence. Because these people cannot get funding in the United States, there's no underwriter who will underwrite their project and fund them. Hence, their need to go offshore to China and India and other countries to get the funding. So it's not a coincidence that most of the EB-5 projects which are seeking funding in China are not able to get funding in the United States. There is a very direct correlation because these may, in fact, be the most risky investments to make. So, again, in terms of speculative ratings, we have the highest category, which is leisure, and that would be casinos, entertainment, followed by tech, healthcare, and building. If you go on to the next slide, you can see, again, showing a very high correlation. We talked earlier about quality, asset quality. You have components in the deal which strengthen the probable outcome, a successful probable outcome. You also may have components in the deal such as lack of credit, other forms of credit, or capital. There may not be traditional finance available from banks and other institutions. So the lower the quality of the deal, the higher the rate of default. And you can see here in this chart that as a percentage, municipal bonds actually fail at a very low rate, while corporate bonds fail at a very high percentage. Again, a breakdown among municipal bonds which do default, and I want to point out this database is from 1958. So over 50 years of data showing the highest rate of failure. Over 1/4 are IDR, industrial development bonds, which are in the EB-5 world, are often used in combination with EB-5 finance to develop the large-scale infrastructure deals. So if you've ever seen a military base redevelopment or a city infrastructure development, typically industrial revenue bonds may be a component of those. Other favored industries which may have a high component of failure would be housing, nursing homes, healthcare, and retirement. So if your clients are invested in nursing homes, assisted living facilities, or housing, real estate, hotels, these, again, traditionally have or may tend to have a higher rate of failure than other asset classes.
Well, Michael, you are the man who paints the real picture. I have said it many times before, doing your due diligence and doing your due diligence on your due diligence people is absolutely critical. We don't want to be that motorcyclist flying in the air. My guess is he probably lands safely, gets up and walks away. Michael, thank you so much for that reality check. We cannot overstate the importance of financial due diligence. The immigration lawyer is help when it comes to immigration risk, but when it comes to financial risk, if you are not a FINRA registered individual, don't go there. You're not qualified to be there. The website to go to, Michael's website, let's slide through. I'm probably all giving you a headache with my little clicking that I'm not that good at, quite frankly. But there's Michael Gibson's slides. We kind of flew through some of them with the statistics, with the analysis. I was actually in China, in Beijing on that day. Michael, we should have got together, but I was in meetings, and it appears that you probably scared the hell out of the agents with those numbers, and thank you for doing so by providing a reality check so that they can protect their clients and their investors and make sure that due diligence is done. usadvisors.org, that's Michael Gibson's website, usadvisors.org, the absolute guru, the gold standard in providing due diligence. EB5info.com is his website. It is just chock-a-block with valuable information, EB5info.com. Michael, thanks for joining us by cell phone where you are out doing due diligence on projects. You were very clear today. All of our audience were extremely helpful. Demystifying TEAs was a critical aspect of this presentation. What I learned is that TEA analysis is 3 times more complicated than I even knew. You do want to be relying on the experts. We've had 4 of them so far today. We've had Aaron Goforth, Dr. Aaron Goforth from Wright Johnson, preparing business plans, economic analysis. We've had Michael Jor, who's left us today. He had to run, who does the securities and corporate work, structuring regional centers. We have had Mr. Elliot Winer, and I should find out if it was Dr. or Mr. Either way, the absolute expert in terms of doing TA analysis. Michael Gibson, FINRA registered, our due diligence expert, and your host today, Bernie Wolfsdorf, with a crackly, strange voice, cracking really bad jokes again. I do apologize for those, but we've kept you for an hour and a half. I'm now going to see if we have questions. It is our policy to answer every single question we get. So let's open this up to question and answer and see if we have any questions from our audience today. I haven't mentioned that yet. Oh my gosh, we have a lot of questions. So there's a good question from my friend Joel Paget in Seattle. What does shortly mean? Sorry, Joel, I was waiting for everybody to get online. I do apologize. We started a few minutes late. What are problem issues with job calculation for new hotel construction? Problematic issues with job calculation for new hotel construction. Aaron, that's your baby.
Yeah, I think the only concerns that we have is that the job estimates, whether it be direct to indirect, so the number of folks you're going to hire, are within industry standards and appropriate for that class of hotel. So HVS, PKF, and others provide evidence based on historical data of how many folks you may hire. The alternative is, if you don't use a direct and indirect multiplier and you use an expenditure model and a revenue-based multiplier to calculate your direct and indirect jobs, you need to make sure that those revenue projections are within industry standards so that the occupancy and ADR are realistic for that marketplace and take into consideration the competitive set. And again, the data is supported by that third-party verification that these numbers are reasonable. And then as it relates to job creation broadly, you know, we just need to make sure that we're talking about full-time employees and not full-time equivalents, which is a critical component of the regulation.
Aaron, hotel projects continue to be very popular together with assisted living, large-scale residential projects coming in through job creation. By the way, we have a ton of questions. I am going to ask that we provide relatively short answers so I can provide answers to everybody who's put their question. Those questions came from my friend Yong Noi, an EB-5 immigration lawyer with considerable expertise. Also coming from, if those of you want confidentiality, I apologize. Does USCIS current hostility on EB-5 projects involving tenant occupancy, that is, new office building with office tenants to occupy later, mean that the new office building projects will not work anymore as an EB-5 project? Aaron, give us the short version of our problems with tenant occupancy. My personal view, tenant occupancy, giant headaches, absolutely critical to make sure that you have addressed the tenant occupancy issues. As far as I understand, if you have 526 approvals, you're probably going to be grandfathered in with projects that are in the pipeline. But for new projects that have tenant occupancy, I know the matter is subject to litigation, but the simple bottom line is we have a huge project. Let's talk about tenant occupancy moving forward. See if you can give us the short version, Aaron. Hello, Aaron. Hello, one. Have we run out of time? Aaron, are you still there? Oh, gosh. He sounds like he's still there. No tenant occupancy? Oh, my gosh. All these folks have been standing, waiting. Aaron, are you still there? Nope. Aaron's gone offline. We are going to have to do our tenant occupancy analysis. I can probably take that for you, Aaron, but what I'm going to do is move forward on some of the other, I assume Aaron, he did mention to me that he had to leave at 2 o'clock, so we've probably lost Aaron. This is a question that will come over to you, Michael Gibson. Is due diligence required on investors or project developers? Who requires this? Well, Michael, due diligence, do we need to do it on the investors to make sure that the investors are in fact qualified investors or project developers? My quick answer is all of the above, but Michael, please give us your summary on this issue.
Well, you know, due diligence is not required by the law unless, interestingly enough, FINRA just released a interpretive letter which we posted on EB5news.com if there's any regional centers or broker-dealers who are listening in on the call. And they are requiring due diligence by the issuer or the broker-dealer so that they understand what is involved in the offering and if it's suitable for the clients. But for the immigration attorney, it's not required. Now, the difference is it's something what you and I would call a best practice. And I think we do that, or most of the immigration attorneys who contract us to perform due diligence do it because of something that they call due care. And the concept there is that they care about their clients and they want to make sure that they don't make a bad investment decision rather than rely on a limitation of liability which may be enclosed in the engagement. So their preference is that their clients invest in a high-quality, strong project rather than having to try to defend a possible relief action down the road. So it's not required by immigration attorneys or even investors, but I think for those who make an investment, same as you or I would if you were to buy a house or a complicated instrument, you would want some opinion, a third-party opinion, as to whether that was suitable for you. I think this is a concept which is somewhat new in the EB-5 world, but in the terms of capital markets and investing in other asset classes, it's not new, and I think it's now gaining acceptance as we can start to see the failure rate of other projects starting to increase.
Michael, another question, is the municipal bond purchasing now allowed under the EB-5 project?
Well, that's a great question. Interesting that you should ask. My understanding is that in the 520 bridge project, which invested in the 520 municipal bonds in Washington, they did actually get 526 approvals. So, you know, I think there was a question regarding...
Can I stop you at that point, Michael? My understanding is that the exemplar was approved on the Washington 520 project. I am not sure they actually have 526 approvals, but perhaps you can give the final spin on that. I do know that the exemplar was approved a few weeks ago. I'm not sure that they have 526 approvals yet, but maybe you have more current information than me.
Right. Well, concerning the project, if they got the exemplar approved, then the only way the 526 could be denied would be based on the investor's own personal issues, either source of funds or background. So speaking from a project standpoint, I think if the question is, could people invest in a municipal finance project by purchasing the bonds, my understanding is if the exemplar is approved, then I believe USCIS has approved the model.
Right, that is correct, but there are other issues attached. So my question to you, Michael, isn't that a game changer in the entire EB-5 arena? The risk factor there was 0.003%. Apparently that is sufficient at risk for the EB-5 Regional Center program. Is this going to change the nature of the beast?
I think completely. If you come from the assumption, which is, I think, been proven, that these private equity investments are extremely illiquid and highly risky, and I'm speaking of investments into some of the asset classes which we mentioned earlier, the large-scale infrastructure redevelopment, some of the other industries like the entertainment and leisure industries. If you compare that to a municipal bond investment, then I would say absolutely. If the goal here is to invest in the lowest risk asset class, then you would be hard-pressed to find one safer than a highly rated municipal bond.
Michael, another question to you. Don't you run into significant conflict of interest issues when you are preparing both the Regional Center 924 and the investors 526? So if you're representing the Regional Center in setting it up and filing the 526s, are there potential conflict issues?
Sorry, Bernie, is that question to me?
Yes, sir.
Well, the good news is we do neither. So we don't prepare 924 applications or file 526. All we do is risk analysis and due diligence on the investment.
Well, let me take the question. My feeling is that there is not necessarily a conflict. There's a potential for conflict. The role in setting up the regional center should be fully disclosed. Waivers should be clearly outlined in your contract with your client. So I don't see a major problem with that. Thank you so much, gentlemen. Are regional center designations transferable? CIS, USCIS recently made it very clear that there are restrictions. I'm going to try and fly through some of these questions, just recognizing the value of your time. Any information on processing delays? 924 is much faster. 526s remain considerably backlogged. 6 to 8 months is a norm right now. A little bit of inside overall information for you. We are seeing a faster approval on smaller projects, that is projects in the $10 to $20 million range, than in some of the larger projects, presumably because the job count is a little bit easier to determine in some cases. Elliot, I don't know if you're still online. There's a question here. Have you worked in Washington State? My guess is Elliot's worked in every state.
Yes, I think every state but Alaska, I think.
Thank you so much. Really, your presentation was just absolutely superb. Are the slides going to be available? Yes, they are. Go to my website, wolfsdorf.com. Folks, I'm going to recognize your time and respect your time. We've been going for a considerable period of time today. Thank you so much for joining. I apologize for the 5th time for my squeaky little voice. Thank you to all of our guests. Elliot Winer really opened my eyes on TEA analysis. Michael Gibson, our due diligence analysis, always gets me somewhat depressed I'm going to be a little bit more optimistic. Mike, thank you for that reality check that we need so clearly. Aaron, who's left us today, absolute expert in economic analysis and business plan preparation, and my good friend Michael Jor, in terms of preparing securities documents. This is an amazing team here. You can see that regional center setup, operation, and processing of EB-5s is a team effort. This is an excellent team that we have today. Our next webinar will be in November, but I do change the dates from time to time, so keep posted. We will email you with the dates. Thank you for joining us today. Please spread the word. We got over 300 people registered for today's webinar. The goal is to push it up to 500. We have a superb audience. Thank you all for participating. It's been an absolute pleasure. And until next time, we shall talk again, friends. Thank you so much.